with unlawful carrying of a weapon, you're facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On April 20.
Notice what's happening here. The entire case hinges on two things: witness testimony and a backpack. No fingerprints, no DNA, just an eyewitness saying, yeah, I saw him hide it. Question for you, is that enough to convince you? Or would you want harder proof before calling someone guilty?
2025 in Harris County, Texas, a law enforcement officer was dispatched to a disturbance of a weapon call at a hotel. The hotel staff said that an unidentified third party alerted them that the defendant had a weapon. The defendant was detained, and a witness told the law enforcement officers that the defendant had a backpack behind a bush prior to the law enforcement officers' arrival. The backpack was recovered, and a handgun was found in the backpack. The defendant is currently 19 years old.
You like Skip. How do they know the backpack was his? What was he doing wrong?
There was a witness, Your Honor, that stated that they saw the defendant hide the backpack behind a bush, and the hotel staff was able to identify the defendant as the individual they were told had a gun. And that's when the officer.
Was he just standing while black or something? What's he doing wrong?
They were just alerted.
No. I'm going to find no probable cause in your case, Mr. Narcisse. Be careful, man. So many out there out to get you, put you down. You know, you're 19. Do something with your life. Don't become a statistic. Hang tight for me.
We're approaching on Mr. Jeremiah Cummings. That's the one about the deadly conduct.
I don't remember. I mean, I don't remember what I had for breakfast, so you're going to have to refresh my memory. What happened?
Yes, sir. I'll just read the summary. On April 11, 2025, in Harris County, Texas, an officer was dispatched to a family disturbance call and met with the complaining witness. The complaining witness said that an argument occurred between her and the defendant, and that the defendant grabbed his handgun and held it in his hand as his anger intensified. The complaining witness left the apartment due to fear, returned to the apartment and contacted the sheriff's office to report the incident. When the officer approached the defendant, he stated, "I'm not talking, I'm answering questions." Gathered his things and grabbed a handgun and placed it in his hand. The officer then drew a weapon and said, shoot me then. The deadly conduct, Your Honor, is alleged based on the fact that the defendant was holding the gun during the argument with the complaining witness.
Does that mean that if anyone ever gets into an argument and has a gun in their hand, that they're literally, I mean, theoretically guilty of a deadly conduct just by virtue of, and then what kind of argument can it be? What level of discourse must there be for someone to be, you know?
Right, and
that can't be the law.
This is the gray zone of law, the difference between having a gun versus using a gun. Prosecutors love to argue that waving it around equals deadly conduct. But here's the kicker. Intent matters. So, was he threatening or just reckless? That's the million-dollar question.
Talk about this one where it's not a terroristic threat or an act, nothing was really said, it was like pointed at her. We have also spoken.
So, I mean, think about this. Like, let's say you and I are arguing, right? And I'm mad at you, and I just, you know, I get the gun just to put it somewhere else, you know?
Right. I get it. And I mean, wasn't charged as an act.
I get it, but
we have spoken to the complainant. I think I remember last time with this case, you wanted to hear from the complainant, just before you made a PC.
do you have anything else?
She's not, from what we can see, she's not. She wants to be around him. She said he had a gun.
Is he here?
No,
He's
he
not here.
waived his appearance.
Right. I remember. Yeah. All right. I'm going to find no problem.
All right. Did you want to also then speak to Mrs.
Come up, ma'am. You tested positive for meth. I can't let you go. That's just it's too much. You know, I have to revoke your bond, ma'am.
I don't do nothing. I'm prescribed.
I just tested you. You tested positive for meth.
Yes, sir, but the medication that I'm taking, that's why I've been trying to get it.
Adderall doesn't test positive for meth. Show me a study, show me something that says Adderall tests positive for meth, but no, I don't believe that's a good, I mean, I'm in pre-trial, it's just. Have you heard of Adderall testing positive for meth?
I have not heard.
No. You're supposed to give, when you're being supervised by pretrial, you're supposed to give them any and all prescriptions that you're taking so that they can cross-reference any positives with any kind of drugs that you're taking. Adderall doesn't test positive for meth.
That's not the only thing that I'm taking, sir.
So when she was in court the first time, she really was, in a blank state.
I get it.
mean,
I'm not
and-
talking.
And so at that time, when I asked about all the different prescriptions, she was very like scatterbrained. She was able to provide me with the prescriptions that they gave her when she went to the hospital for the assault.
So let's do this.
So-
Let's do this.
Uh-huh.
I will give, you can give that to them so they can check it out to see if there's something that will possibly test positive for meth. But I just don't think there is. You're not, I've ordered you not to use alcohol, illegal drugs, you're not to use. There may be things that happen in our lives. You're supposed to find a good way to be able to deal with, PTSD. We all have it. We all do. But you have to find a positive way to deal with things. And illegal drugs is not it, especially when you're on bond for a very serious crime. So take a seat from the jury box. I will have them check it out to see what, if anything would, but
Just for clarity for the court, she's already provided prescriptions that she has when she went to test.
I don't know, maybe she has something different. And have you looked at all those prescriptions?
I mean, all that's been disclosed is two of the
Okay,
prescriptions.
ma'am, take a seat for me in the jury box. Morning, Mr. Coates.
Good morning, sir.
How are you?
Iffy.
You're here because we had to issue a warrant.
Yes, sir.
It's the only way we get to see you. We asked you to do things. You told us you were going to do things, promised us you were going to do things, yet
Half that reasoning is on my aunt because she is my ride to most of these things, and she couldn't help me out. I got into it with her with my sister over some money issues because remember when I was working at Dave's. So after that, she was like, "You got to leave," because she wasn't trying to hear nothing I was saying, and I wasn't being disrespectful or
I
nothing.
wouldn't want to either.
But
It looks like you're already starting to blame everybody else.
I'm not like,
But you are.
yes, sir,
At the end of the day, it's all
on me.
on you. When you have the heart, when you have the will, you can do damn near anything. If you really wanted to, you could find a bus, could call a friend, could take an Uber.
It's hard when you're watching two kids, sir, and working. I was watching two kids, my baby brother and the kid that's mine but not mine. And I'm working. And also, we had a deal on me doing my GED. I was working on that. There is proof for that. Literally.
We don't have proof of anything.
The other lawyer, that other lady that was in here, I forgot her name, but she was seeing somebody else. That was my first court-appointed lawyer. She has that proof. She showed y'all that the first time.
That was before you got on probation, dude. You're supposed to continue with it.
Before I got on probation, I thought I was on deferred. This was while I was on deferred. The deferred deal was if I did that, I was getting off of that in 3 months. That's exactly what you told me, sir. I'm not lying. I'm not trying to bring nothing back. I'm not trying to argue. I understand where I'm wrong.
I get it.
You know what I
The
mean?
problem is, in this world, you're only as good as the proof that you have. If you don't have proof, you have nothing. So you tell me this, you tell me that. I ask and I have staff that tells me, okay, this is what he's done. This is what he's not done. He hadn't even shown up once. You didn't even show up once. Did you get your offender identification card? That's the first thing that you got to do when you even get on a deferred. You literally done nothing. So what now? I truly don't know how to go forward. So what I would like to do is do a TRAS. This is an evaluation to see where we go from here.
Wednesday.
We have, I'm going to expedite it so you don't just sit there. We have the TRS set for Wednesday. I'd like you to talk to them to see how we go forward, and they'll give us an analysis, and they'll, talk to you, see where you are in life, what's gone on, and give us a better indication of how to go forward. But I just don't
Trying to
know.
lose my job. I just found a good job. I'm learning this, what's on your table, that marble, I'm learning how to cut that and polish that. Like, it's a good job. Like, I understand I was supposed to do these things. Like, I've missed these things, and it's no apology could fix that, of course. But again, there was a lot going on in life. It's no excuse. It's no excuse to what I was supposed to do, and I knew I was supposed to do it. But it was a lot going on in life. My auntie was half the reason of me being a ride. She was my ride, and I don't have that ride. So now everywhere I do go, I do need the metro now, which is not no deal, because now I'm doing this on my own. You know what I mean? Like, I ain't got to worry about kids. I ain't got to worry about no other jobs. I really wasn't though, sir. I really wasn't. I was having resources. I was having y'all help me out with this too. There's probably no proof there with that, but I was.
Be that as it may, I'm doing this TRS. I'm going to try to get it done as quick as possible. I'm going to try to get the results as quick as possible to see how we go forward, because I just don't know.
Can I have a bond?
I did set you a bond. I always set you a bond. I don't hold people at no bond. Very, very few instances can I really legally hold someone at no bond. But it would be foolish for me to just think that let you out and hope that it happens again.
I
Because
really don't like coming in here. You ain't gonna see me no more. I know you can't just do it, because again, what I already did puts an image out on me that I'm not gonna do anything for it. Like,
not
I understand.
reality. Perception is reality.
Yes, sir.
So we'll set you for Wednesday. I'm not going to set you. You want to set it for Friday?
Yes.
We'll set it for Friday. Hopefully we'll have a good roadmap of how to go forward on that day. And in between, we have Sean here to help you out. You can always talk to Sean. He's great for whatever you may need. And then I'll see you back on Friday.
Judge Bond's set at what, 10,000 right now?
It's set at codes.
How long a time I'm looking at if none of this go through? A whole year? Great.
The reason I have it the amount that I do is because of his multiple non-appearances, multiple bond violations. I have at least probably 3 different times he failed to appear. As far as bond violations, I have,
2 of those.
yeah, 2 bond violations. So, and now a motion to adjudicate. So I really think that just bond is appropriate as how it's set now. See you Friday.